Good evening. I'm Sarah Watson, the director of the Murphy Institute at CUNY School of Labor and Urban Studies. Welcome to the second session in the three-part series, Labor Organizing and the National Labor Relations Board, the Impact of Recent NLRB Decisions. This program is co-organized by the Murphy Institute at CUNY School of Labor and Urban Studies, the Labor Education Action Research Network, LEARN at Rutgers University, and the Scontras Center for Labor and Community Education at the University of Southern Maine. I want to thank the public engagement team at SLU for facilitating tonight's program, and to my colleagues at Rutgers and the University of Southern Maine for their collaboration. Tonight's program, titled Making Big Bosses Bargain, the New Joint Employer Rule. And I'm thrilled to have tonight Ellen Dichner, Distinguished Lecturer at CUNY School of Labor and Urban Studies and former Chief Counsel to the chair of the NLRB under President Obama, and Millie Silva, Secretary Treasurer of 1199 SEIU, United Healthcare Workers East, speaking tonight. Our moderator for the program is Cameron Black, Assistant Professor of Labor Studies at CUNY School of Labor and Urban Studies. Cameron is a historian of the United States, and his fields of interest are 19th and 20th century labor and cultural history, student-athlete protest in the 1960s, and the history of capitalism. He studies the intersections of race, class, and labor, and how we think about who qualifies as labor and what processes go into these distinctions. It's my privilege to welcome Cameron and to turn the program over to him. Thank you.
Good evening, everyone. I hope that you are all doing well. It is my pleasure to also to have a couple of brief introductory remarks about Ellen and about Millie. Of course, Ellen is a distinguished lecturer in labor studies at the CUNY School of Labor and Urban Studies. She's been practicing labor and employment law for nearly 3 decades, and most prominently was chief counsel to the chairman of the National Labor Relations Board. Before her time at the NLRB, she also was heavily involved in labor law. She was a partner at a New York City law firm where she handled a wide range of matters about workers and unions. And in this situation, this is how she met our other guest, Secretary Treasurer Millie Silva. Millie is the Secretary Treasurer at 1199. This role is the second highest elected position at the 1199, and with a deep history in the civil rights movement, this union played a very prominent role. Born in the Bronx, Millie started her career as a community organizer and still maintains this passion for community organizing. At this point, I would love to pass the chair over to Ellen, and we can get started from there.
Thank you, Cameron. Hello, everybody. So I'm going to give a presentation to start this off on the NLRB Joint Employer Rule. On Monday, this coming Monday, the Joint Employer Rule issued by the Biden board is slated to go into effect. This rule essentially reinstates the joint employer standard adopted by the Obama board in 2015, which was reversed by the Trump board in 2020. So why is the joint employer rule so significant and controversial? And what is the labor problem the rule seeks to address? Next slide, please. The NLRB's rule on joint employers aimed at addressing the modern day fissured workplace, a phrase coined by David Weil, who was head of the Department of Labor under Obama Standards Office. And he was actually appointed by President Biden, but was never confirmed by the Senate. But he coined this phrase, the fissured workplace, to describe what we face today, where companies outsource various operations to other entities that provide workers to perform the work for the company. So instead of directly hiring workers, they utilize third parties, such as staffing agencies and contractors, to supply labor, while at the same time, that company possesses or exercises control over these workers who are supplied to the company. Thus, these multiple companies share control over various components of the workers' terms and conditions of employment, such as hiring, wages, discharge, supervision, etc. For workers, this blurs who their employer is. And through these arrangements, companies reap profits from the labor of these workers, while at the same time claiming they are not the employer. This allows the company to avoid liability under laws that protect workers and set labor standards. And it is also a way to avoid unionization. These are the common joint employer relationships. Staffing agencies, contractors or subcontractors, franchises, entities which companies use to avoid being the direct employer of workers who do the work of their company. So for example, Home Depot fired its maintenance employees and hired a company to provide staff to clean the stores. So the staffing company hires the cleaners, their paychecks are paychecks from the staffing company, but Home Depot tells the workers what to do in terms of cleaning the stores. So under the rule that was implemented by the Trump board, Home Depot would not be a joint employer because it does not have substantial direct control over the terms and conditions of employment for these workers. Under the Biden rule, to go into effect on Monday, that rule does not require companies to have direct control, and therefore Home Depot would be a joint employer. The joint employer arrangement primarily arises in two contexts. The most common is in the area of NLRB representation cases. This is where unions seek to organize workers hired by a staffing agency. The union files a petition for an election and names both the staffing company and the company where the employees work, so that if they win the election and they get to the bargaining table, they will be able to bargain with both joint employers. Similarly, we see the situation where a company hires agency workers to supplement its workforce. This is common in healthcare and tech. Google notoriously hires lots and lots of agency workers. In fact, they use more agency workers than regular workers, and these workers work side by side with Google techs that Google directly employs. So you've got one group working together, employed directly by Google, and then another group doing the same thing, working at the next desk, but employed through the staffing agency with lower wages and fewer benefits. In this situation, the union can seek to represent both groups in a single bargaining unit. That is, it would seek to represent the agency workers and the workers directly employed by Google. And so in that NLRB election petition, the union would name both employers. And again, if they win both employers, you'd have a bargaining unit of both groups, and both employers would have obligations to bargain over certain terms and conditions of employment. The other context where the issue arises is in unfair labor practices. Taking the Home Depot example, the union begins an organizational campaign to organize workers provided by the staffing agency. Home Depot's supervisor observes some workers supporting this effort and tells a staffing agency it's unhappy about this and the agency better do something about it. And of course, the agency will if it wants to keep the work. So the agency fires the workers. Under the Biden rule, the new Biden rule, Home Depot would be jointly liable for the unfair labor practice of discharging the workers because it was indirectly, even though it was indirectly responsible for the discharge. But under the Trump rule, Home Depot would not be liable because it did not directly discharge those workers. So only the contractor is on the hook in that case. So what is the new Biden NLRB joint employer rule? So the rule is 2 or more employers may be considered joint employers if they share or co-determine one or more of the employee's essential terms and conditions of employment. How does this rule help workers? As described in the Home Depot example, a joint employer will be obligated to recognize and bargain with the union over essential terms and conditions within its control. And it is easier to hold the joint employer liable, each liable for each other's unfair labor practices. So let me break down the rule a little further. Next slide. The Biden board has identified 7 essential terms and conditions of employment that they will consider in determining whether a company is a joint employer. This is a pretty exhaustive list, and an entity that possesses control over one or more of these conditions of employment will be deemed a joint employer of the workers. That is, Home Depot would be deemed a joint employer of the staffing agency. Please return to slide 4, which is the rule. Okay, well, I'll just repeat it. So the joint employer rule under the Biden rule and also under the Trump board requires that to be a joint employer, 2 or more employers must share or co-determine as these essential terms and conditions of employment. Under the rule, when the rule refers to co-determining, sharing and co-determining, what it's really referencing is the type of control each joint employer possesses. So under the Republican NLRBs, the Trump NLRBs and the NLRB, Republican NLRBs preceding President Obama, the board required that the control over terms and conditions of employment be substantial, direct, and immediate. So these employers were able to avoid responsibility simply by bringing that third party in, even though the company reserved the power to call the shots or called the shots through an intermediary. The Biden joint employer rule rectifies this. Slide 7, please. The employer can be deemed a joint employer under the Biden rule if it does not exercise direct control, but has the authority to control at least one of the essential terms and conditions of employment. So it can, if it reserves control or it indirectly controls, the rule says that this is sufficient to establish joint employer status. Next slide. So what is reserve control? What is the board talking about? The rule says that a joint employer who maintains authority to control essential terms and conditions of employment will be deemed a joint employer, even if it has not exercised such control. So for example, the company states in its contract with the staffing agency that it reserves the right to unilaterally establish or change employee conduct rules whenever it wants, but it hasn't done so. Under the Biden rule, just the possession of that authority, exercised or not, is sufficient to establish joint employer status. The other big change that the Biden board made is over indirect control. Next slide, please. Both the reserved and indirect control change reinstates the way the Obama board had defined the rule as well. And indirect control is where the employer works through a third-party intermediary. So its control need not be direct. If the company contracting with the staffing agency sets a term of employment, for example, training, but only the contractor is responsible for enforcing that training policy, the company, which has something to do with implementing it, is indirectly controlling. And that is a basis for determining that the company using the staffing agency is the employer, is the joint employer. So how does the Biden rule impact collective bargaining? Under the rule, workers are able to bargain with the entities that actually have the power to meet their demands, rather than limiting bargaining to the entity that appears on their paycheck. If an employer possesses control over terms and conditions of employment, and that employer is not at the bargaining table, the workers aren't able to bargain with the entity that can actually deliver. Each joint employer will be obligated to bargain over the essential term and conditions of employment that they possess authority to control. Unions can't effectively bargain if the companies with control over the issue aren't at the bargaining table. Of course, the joint employer will not be required to bargain over subjects that it does not control or have the authority to control. The joint employer rule and the changes in the Biden rule will have a significant impact. Some of you may be familiar with the nationwide unfair labor practice case the NLRB brought against McDonald's and its franchises in 2014, when McDonald's retaliated against the workers who were fighting for a $15 minimum wage. Last year, Google workers and the contractor filed a petition for representation at the NLRB, claiming both the agency workers and Google were joint employers. Issue comes up a lot with delivery drivers, a lot of cases involving Amazon, and a very timely example, college athletes. Right now, the NLRB General Counsel is prosecuting unfair labor practice charges against the University of Southern California, the NCAA, and Pac-12 as joint employers of college athletes. I'm going to end there, and I will take questions at the end of the session when it's open for questions and answers. Thank you.
Thank you, Ellen, for your presentation. I learned a lot just listening to you. I would also like to introduce to bring back Millie and add to this conversation as well, and maybe opening up just a little bit. Millie, I'd like to ask you, like, how has these sort of debates and fights over these particular regulations affected your industry? Like, how has this played out in healthcare, for instance?
Sure. So Cameron, thanks for the question. And what I want to do for everyone is level set for a moment, right? And actually, Ellen mentioned Home Depot. and I'm going to speak to Home Depot and its connection to nursing home workers. But I want to point out, many of us might think of nursing homes at the moment where we might realize that we have a grandma or a grandpa that needs care, or we have an aging parent who can no longer remain at home. And so we might choose that the nursing home is the next place for them to receive the care that they need. And in fact, we also know that there are people who have pretty severe disabilities and then also might be living at a nursing home. Today, right, there are about 1.3 million workers throughout this country who actually are employed at a nursing home. And what I'm going to ask you to think about is that the nursing home is usually the place where people go because they need care. Many residents at nursing homes might live there anywhere from 1 to 3 years. But in fact, what I'm going to ask you to now think about is the nursing home is a very complex workplace, right? It is an industry that is more and more owned and operated by for-profit corporations. So when you hear workers and they are chanting people over profits, it is usually in reference to who the owners are of many nursing homes these days. Many of the workers are low-wage workers themselves. And the reality is that the product that those workers are producing is care, right? They are caring for people who are in a vulnerable state and need the best level of care that's possible. And in that context, you know, thinking about COVID for a moment, the image for many people about what it was like in nursing homes were the images of certified nurses, aides who were making demands to be able to have masks, to be able to cover their faces and protect themselves and not move the virus from patient to patient across the nursing homes. Here in New York City, you may have seen the images of those trucks outside of nursing homes that were being used to be able to hold the bodies of residents who had passed away, and the funeral homes could not accommodate them. And so you had nursing home workers who were going into the facilities every day to provide care. They had patients who were dying, and you had trucks outside of those nursing homes. And then the last thing is, and if you know anybody who had worked in healthcare during the pandemic, you know, certainly nursing home workers shared the same stories of what it was like often for them to come back to their apartments or to their homes and to strip down their clothes outside of their home because when they stepped through the door, they wanted to do what they could to make sure that their family members might not get exposed to what they had brought home from work. In that context, now let's talk about this joint employer rule. And so what happens is in nursing homes, you have two ways in which the employers will deal with that workforce whose primary mission is to provide care. One of the things that they will do oftentimes is that they might actually hire or use subcontractors to be able to provide some of the services to the facility. So think of the people who are providing the meals at the nursing home. Think of the people who are cleaning and sanitizing the facility and making sure that the aides have the supplies they need throughout the day. Sometimes nursing homes will then hire other companies as the provider of those services. And so the workers are told, you don't work for ABC Nursing Home, you work for this company that is the cleaning service, or you work for this company that is the sort of providing the meals, the dietary services, et cetera. But the reality is that on a day-to-day basis in that facility, it is not just the immediate supervisors of dietary and housekeeping who are deciding what those workers are doing. It really is management at the facility. So both dietary supervisors, the housekeeping supervisors, but also the nurse who might be in charge. Also the director of nursing, if they feel that they saw something that they're not comfortable with, they also play a role in being able to direct what those workers are doing. And so in those situations, when workers have a problem, sometimes they're told by the nursing home, well, we can't do anything about that because we're not your boss. But in reality, we know, and because they're getting a check that says that they work for, you know, XYZ cleaning services. Well, in reality, their paycheck may be coming from XYZ cleaning services. They're walking into their institution at ABC Nursing Home every single day, and things that have to do with what equipment they have, what they're being asked to do, how they're asked to work with the rest of the nursing team, that's not just being decided by the cleaning service that's off on the side. That's actually being decided on a day-to-day basis by the nursing home. So that's one. And then the second is in particular as it relates to the direct care staff. So I mentioned the certified nurses aides, but then you also have nurses who are responsible for providing care at the facility. We saw this before COVID, and we also continue to see this during COVID. Nursing homes would then hire nursing staff from agencies to come into the facility to provide care. They would argue that they didn't have enough of their own staff in order to provide bedside care, and so they hired agency workers to come in. Well, in reality, what happens is that one, in some cases, we saw that the agency that was the temp agency for the nurse might actually be a temp agency that has a relationship with the owner of the nursing home. And so I'm Millie, I'm a nurse, I'm assigned to come to the work at the nursing home, and I'm getting paid by this agency. And again, management will say, they're not our employee. We're not, so, we don't have control over what happens with them. But there's actually sometimes a related party relationship between that agency, or what they will say is, well, then we're just going to get rid of them and we're going to send us another agency worker. And again, in an industry where the product is care, to then say that we're going to have a revolving door of nurses in and out of the facility who are agencies and they're not our employees, but the director of nursing is assigning that staff. There are other supervisors at the facility who are day-to-day directing that staff in terms of the work that they do. It makes it very difficult to believe, certainly in practice, and then we're sort of glad to see that the law is changing, that these workers are somehow not employed by the nursing home.
Maybe a follow up for you, Millie. I would love to sort of hear about how the Trump administration's decisions around this Joint Employer Act has actually impacted conditions on the ground. You talked, I think, at length and very eloquently about COVID and the experiences about that. Did this change in joint employer law impact conditions on the ground in that particular way?
I mean, I think that the nursing home workers have been a part of sort of doing the work under sort of the Trump rules about sort of how ownership is seen at the nursing homes. And so one way in which you see that is that, for example, when we're bargaining, you would have, again, I mentioned sort of people in the dietary departments or in the housekeeping departments. Well, so you're negotiating for the workers who are all at the facility, and workers determine these are the kinds of things that we want to see in terms of improvements of our wages, in terms of our benefits, in terms of working conditions. And so in that context, what can sometimes happen is that the nursing home would take the position, and we sort of refer to it as like the main house, right? The main house will say, well, look, we're going to bargain with you over the certified nurses aides and those set of workers. But dietary and housekeeping, you need to get them to agree to whatever, you need to deal with them separately. And so as we've always taken the position, well, all right, dietary department owner, you're not, or housekeeping employer that you act as if you're totally separate from the nursing home, but you're not, we're going to ask for the same kinds of improvements for the people who are providing meals and keeping the institution clean as we are for the nursing staff. We're expecting that you're going to bargain and understand what we're bargaining and what we're asking for is for everybody and not the same. And what we have found is that it can be very difficult where sometimes the subcontractors will say, look, we'd love to do this, but we don't have the authority to decide on this because we have to then figure out what kind of a rate we're going to get from the main nursing home, or what then we can decide if we can agree to pay the kind of wages and benefits that the workers are asking for. Or then you'll have the nursing home say, well, that has nothing to do with us. You need to go deal with them. And so in a practical level, one of the consequences is that for workers who are at these facilities. And again, except for New York City, where we have some institutions that are quite large and can employ several hundred workers, some of these nursing homes are institutions that might employ 75, 80 workers. It's harder for the workers to be able to leverage their power when they stand together if they're having to deal with negotiating at two separate bargaining tables when everyone understands it is one person or one set of people who are ultimately making the decisions about what the labor costs are going to be, and that's the Maine nursing home. And so under the Trump rules, it just makes it harder. And I think that, with the changes in terms of what's anticipated with the Biden rules, we hope it will make it easier for workers when they're bargaining at the table to be in a place where they're saying to the subcontractors, listen, you can come to the table, or you understand that whatever we win for the main house, we're expecting that you're also going to provide for the rest of the workers.
Yeah, it's unfortunate that the Obama rule was in effect for a very short period of time, and Millie's experience has gone on for decades, I'm sure. So we haven't really seen a change yet, but as Millie's describing, it's a race to the bottom with these subcontractors because it's the main house that is funding the subcontractor. The subcontractor rates have to be competitive enough, i.e. low enough so they get the contract. That then means the workers are getting really substandard wages. And it's that whole system of this race to the bottom that the joint employer relationship permits, because there's this falsehood that they're two separate employers, when the real control, as Millie has so well described, rests with the nursing home, the main house.
Ellen, I would love to maybe sort of branch out a little bit. We heard a lot about nursing homes. What other industries actually practice or would delve in these particular labor practices?
Well, it's most prevalent in low-wage industries. And it started out, in fast food, but it's in hospitality, janitorial, delivery, warehouse, healthcare. And more recently, we have seen it move into occupations and areas that never thought they'd have to deal with it. I mean, lawyers are now seeing work being outsourced, and as I mentioned earlier, tech. So, but it's mostly concentrated in these low-wage industries. It's very pervasive in these industries. I think that there was a statistic that something like almost 20% or 18%, I can't remember exactly, of private sector workers are working in this joint employer situation. And it's something that's increasing very, very rapidly. But given the workers who occupy these jobs that I've described, the lower wage jobs, they're workers of color. They're women. It results in greater economic inequality to be able to divide workers in the way that this rule has historically permitted employers to do. And now we see it in sports.
We definitely see it. We can see it in sports as well. Maybe I would like to kick the question back to like when we think about these rules from, for instance, the NCAA and trailing down into other universities, how might universities and the NCAA sort of navigate around this new joint employer rules that they historically had not been obligated to follow?
Well, the organizing of athletes at universities is very new. I think the big change actually came in 2016 when the NLRB found that graduate students, teaching assistants, research assistants, were employees. And the fact that they were also students didn't mean they weren't workers. And so we've just very recently seen, I don't want to call them student athletes, university athletes, making the similar claim. And so what you have in this situation with university or college athletes, they have to first show that they're employees under the National Labor Relations Act. And so that was the issue that was decided in the Columbia University case. And so, they have a similar relationship because they're bringing wealth, they're bringing students to the university. University is benefiting from their labor, and they get certain economic benefits in exchange, tutors, scholarships, etc., things like that. And then you get to the joint employer issue. Once you've established their employees, you get to the joint employer issue. And in the NCAA University of Southern California case, that's a really interesting case because it arises in what the general counsel is alleging in that case is that by classifying these players as non-workers, they are depriving them of their rights and protections under the National Labor Relations Act. And that's an unfair labor practice to deny rights to organize and the other rights that the law provides. So they're in the middle of an evidentiary hearing, and they've taken in evidence of the power and control of the coaches and the administrators. It's very, very intense, and how they have to follow the NCAA rules. So we'll see what happens, but the universities clearly do not want these athletes to be considered employees under the National Labor Relations Act, because then they'd have to bargain with them if they unionized. Now they set terms unilaterally, however they want. And certainly the NCAA is really concerned about this because the impact it could have in that whole industry is quite phenomenal. I mean, 20 years ago, professional athletes weren't unionized. Well, look at that world now. So it's a domino effect that they're worried about.
I have to say that one of the things that jumped out at me in just scanning about the USC case is this question around what's expected of those university athletes, and just both sort of like, these are the amount of hours that you're going to be working. This is what's expected in terms of meetings that you have to participate in, along with the training, along with the exercise. And yes, it reminded me of when nursing home workers are told you can have a lunch break or a meal break, right? And yes, if a coach tells you you need to eat a sandwich because we want you to bulk up, you're going to eat that sandwich, and you understand that that's really not a choice, but that you're expected to do that as part of your being in the program. And so it was, interesting to me to see the point being made about how these university athletes are in fact employees. And then it will be interesting to better follow, what is the university, what is Pac-10, what's, conference versus the NCAA, and how it all gets sorted out. But sort of this question about choice in terms of what you're able to do on your day-to-day really resonated with me, because in a workplace where people are expected to work certain hours, are expected in terms of times when they can take breaks, their expectations that are also made around their commitment to the work. I found it, sort of academics versus athletics seems like a false choice, at least if that's what the employer is going to argue.
Yeah, the monitoring the demands and the monitoring. I mean, there they have biometric monitoring, and they do hydration testing, but and they basically surveil. They know where these players are, whether they've gone to classes, whether they've gone to the cafeteria. And it's similar to what you see with Amazon drivers, and I guess probably Amazon workers in the warehouse, but the drivers are a joint employer situation because they, Amazon says the drivers work for independent driving companies, or they're independent contractors, or they've got this other arrangement that they have with companies for the drivers, but they're being surveilled about where they are, what they're doing, very much like these players at the college. And certainly in the nursing homes, many employment situations, workers are being monitored all the time.
In home health care, workers, I think about, I started doing this work long enough that it was before everybody was carrying a cell phone. But employers use the cell phone as the way for the workers to clock in when they show up at their residence home. And so that's their way to sort of keep track and see, did you really show up? Are you there? When did you leave? And so again, sort of the way in which that sort of information is being used to track your whereabouts as an employee. And then I actually am not familiar with what they have in place to safeguard their privacy once they're not at work.
And then in the sort of context of student athletes, there's also this really broad issue from both the NCAA and universities about, well, these folk are not only just not workers, but they're not liable particularly to universities or to the NCAA. So each entity sort of tries to hand off to the other particular claims and responsibilities about what they can or cannot do, stemming from the fact that, at least officially, the NCAA claims itself as a regulatory body without any type of formal employment sort of power. Whereas universities are like, well, what do you mean? Like, you just sent us this 200-page packet telling us how we can regulate student athletes' behavior, how we can surveil them biometrically. In some cases, you can dictate which classes they take and when they take them. You can dictate players' majors and if they can go down certain career paths. It's I think a pretty incredible, fortuitous, I think, development.
And Cameron, it also just reminds me around the question of the demographics of who many of these athletes are. And again, thinking about healthcare, thinking about the workers in the Home Depots and in Amazons and then the McDonald's, these are disproportionately, Black and Latinx folks, people who are, lower income or sort of low to moderate income, in terms of where, what their sort of foundation is in terms of how they're able to take care of themselves on a day-to-day basis. And it really speaks to the demographics of a workforce in this country that is long overdue, being able to have the power and frankly, the leverage and the protection legally to be able to organize sooner and to actually have more constraints around how employers can push back on the workers' ability to organize and also to bargain to improve their wages and benefits.
The fear that employers have that the NLRB is going to more aggressively protect workers has really exploded to the point where We have a number of employers, Amazon, Elon Musk, Trader Joe's, challenging the constitutionality of the NLRB. An issue that was decided by the Supreme Court in 1937. And so this level of aggression, we have not seen since 1937. You know, the fear of unionization and the growth of unionization has, you know, caused these employers to pull out all the stops. I mean, the right now, the joint employer rule, the Biden joint employer rule is under challenge. I mean, it's been held up by the Congressional Review Act, but hopefully that will end next week. And President Biden will veto whatever Congress does, but they brought litigation in courts in Texas. They've chosen Texas to bring their challenges. So, you know, the rule will go into effect, but they will not stop fighting the rule because they want to retain their power.
I think it speaks to the challenge that is occurring as we speak to democracy, little d, in this country, and that those of us who believe and work in organizing labor, if we believe that unions are one of the ways in which we've been able to protect our democracy, it's not surprising to see that something like this rule is going to be challenged in every way possible. Because those who are opposed to workers being able to come together and leverage power to set the table so that it's more balanced, they're going to do everything they can to get in the way and stop it.
No, absolutely. And I guess to add on to that, we see this huge fracturing of the production process, and a lot of and folk that oppose this rule sort of see this fragmentation as a benefit, both to increase profits, but also for quote unquote efficiency reasons, without considering often the toll it takes on human beings as employees and as people. I think maybe I think we have one last question, at least I'd like to ask, and then we can turn it over to audience question and answer. We talked a little bit about staffing agencies and contractors and subcontractors, but we didn't talk as much about, say, how this joint employer rule impacts franchises like McDonald's, right? I would love to hear about how this rule sort of impacts franchisees. After all, McDonald's is so incredibly widespread.
Yeah, the franchise industry is completely freaked out about this rule and has been. There was a case, as I mentioned, in 2014, where the NLRB tried to prosecute McDonald's for firing workers who supported the Fight for 15 movement. They committed other unfair labor practices, and it was nationwide litigation involving McDonald's, the big company, and I don't know, about 30 franchisees. And McDonald's claimed it had no control over these franchises. And so that was the big fight. Were they joint employers? What kind of control did they have over the franchises? It gets complicated because with franchises, you've got this issue of the brand, so the big corporation wants to make sure that the quality of the service or product doesn't undermine their standard. But separate from that, and the rule does, the joint employer analysis by the board doesn't really disturb that. What the joint employer standard is really getting at, the rule is really getting at, is when the company is actually, it's like a puppeteer marionette kind of thing where they're controlling terms and conditions of employment. And I think in the McDonald's case, if I can remember correctly, I think that McDonald's National, which didn't employ, they didn't own many of these franchises. Most of them are independent, but they were providing legal advice about how to deal with the workers who were walking off the job to support Fight for 15. They were providing other kinds of support. I mean, the litigation in that case went on for years and was very hotly fought by the board's lawyers. And it's unfortunate because in the 3 years into that litigation, Trump became president and he appointed a general counsel, the lead prosecutor of the agency, who was a fairly well-known union buster. And he directed the lawyers to settle the case. And they did. The judge rejected the settlement. The judge said, I can't approve the settlement. It does not address so much of what's going on. But that got appealed to the board in Washington, and the Trump board said, looks good to us, and that ended it. So I think that the franchisor, that the owners of these, the entities that control the franchises are fearful that they're going to see this come up again. Some of these franchises really have very little power, and they're being exploited by, the national company. Some of their interests probably are more closely aligned with their workers than with the national company. But the rule could certainly have impact in that area. I haven't seen anything yet bubbling up, but no one was going to do it under the Trump rule. So we'll have to see whether some of this arises when the Biden board rule goes into effect.
And I think in particular, McDonald's franchisees were throughout the 20th and early 21st centuries ways for Black business owners to obtain sort of a stake in communal development. This is this rule could be particularly could prove particularly damaging for McDonald's and useful for these franchisees. I think we can move on to some audience questions. We have, I think, a fair amount of really, really interesting and really neat sort of questions. I would like to sort of maybe have one from Randon Martin. This person's really interested to see about how the joint employer rule could potentially impact gig workers like Uber and DoorDash. How might that relationship work in this particular context?
Yeah, well, with gig workers and Uber, the issue often is, are they independent contractors? That's what Uber and Lyft claim, that these folks are independent contractors. But if you look at the control that the company has over these individual drivers, there's a very strong case that can be made that they are non-independent contractors, but they should be deemed employees of Uber or the gig company and enjoy the protections that workers have under the law, and require these employers to pay for unemployment insurance, workers' compensation, taxes. We have some of these workers who are on public assistance because their employers pay them so poorly, so the employers get that benefit as well. So that's an independent contractor issue, because it's really just the relationship is between the worker who the company is claiming is not an employee and the company. There's a lot of, I expect to see a lot of litigation in this area because the Biden board did issue a decision, I'm sorry, on independent contractor status and what they will look at to determine whether in fact a worker is a worker or an employee as opposed to an independent contractor. Lots and lots and lots of misclassification of workers as independent contractors. Huge problem, huge.
No, absolutely. And I think this is, we'll sort of see where this goes. I think that there was an anonymous user that actually asked, I think, an interesting question about what happens if joint employers disagree with each other during negotiations with the union. Like this, say the parent company disagrees with its contracting, with its contracting sort of employer. Like what happens in that situation, or what could happen?
That's a great question. I can share a couple of stories. One is, in a situation where nursing home workers were bargaining for their contract. They had pretty aggressive demands at the table. They were clear that they were there to negotiate, not just for the nursing staff, but for everyone. And there was an employer, the employer had subcontractors in a couple of departments. And there, it was pretty clear that the subcontractor, at least sort of unofficially to the side, sort of frontline supervisors were saying to the workers, we hope you get what you can, you deserve it, sort of those kinds of comments. I think that the actual subcontractors themselves, who were either going to keep the contract or lose the contract, were worried about what will happen and whether they might then get kicked out, because that's sort of Ellen's point. It is sort of bid with the lowest bid in order to be able to keep the business. And so I think that they were worried, and the main employer didn't want to acknowledge that in fact they had more control over what was happening, with the dietary and housekeeping workers, and wanted to take the position, look, we'll bargain with you over what's going to happen with the nurses' aides, and then you got to go and deal with the others. In that situation, because the workers were able to maintain unity across all of the nursing homes, and they were sort of a group of nursing homes that were all bargaining together. And I think the employer saw that workers were united and were prepared to take stronger action and contemplated a potential strike. The main owner realized, all right, let's get it done. And we will signal to the subcontractors that it's fine for them to go ahead and, give the workers the contract, and it's fine, and the same contract or the same terms. But there's an example of workers really having to do so much, and they didn't necessarily have, I would say, and Ellen, we worked together and sat at many of these bargaining tables together. It's not as if the law was necessarily, sort of protecting the position of the workers. It really was workers and their direct action and engagement and pressure and public pressure that I think sort of boxed in the main employer to not directly say, yes, of course, we'll give them a better contract, or they can keep the contract if they agree to the terms. And then that the subcontractor also understood, we'll try to do what we can, and that there won't be retaliation to them as a subcontractor losing the contract. So, it's complicated, but again, I don't think that's an example of where the law didn't necessarily help workers. And if it's not for the workers' ability to organize and maintain pressure over many, many months, they might not have been able to win a contract that was for all of the workers. And on paper, legally, it was a contract for the Maine set of homes and a contract that was signed by.
I think that's a fantastic story of the strength of bottom-up organizing, and taking advantage of what Ellen ironically termed fissures in these particular relationships. Another, I think, interesting question from the audience, I think by Ruth Milkman. Why did it take so long for this rule to go into effect? And what are the particular political stakes of the upcoming election?
Well, it takes let me see, the Biden board became effective just a couple of years ago, where you had a majority of Democrats on the board. Rulemaking is a very lengthy process. Most of the law that the NLRB passes is through decision making. It's case law, but when it comes to making law through rulemaking, you have to go through this extremely detailed, exhaustive process with public hearings. You have to present a proposed rule of hundreds and hundreds of pages, explaining why you're changing the rule, exactly what the rule means. And then there's a comment period from the public, and they file 20, 50,000 comments. Management gets everyone together to file a bunch of comments. Unions try to get the AFL-CIO tries to get unions to file comments, and then the board addresses many of these comments in their rules, and it's just a very, very, very lengthy process. Ruth's question is the second part's very depressing, because if we don't, if we have a Republican president next time around, we can expect that a Republican dominated board, which would take a couple of years for Republicans to dominate the board, would seek to overrule the joint employer rule. So I would hope that people who are thinking about organizing do it really fast while this rule is in effect, because if you're able to get recognition by a joint employer under this very under a rule that's much easier to establish joint employer status, get it done. Don't wait.
Shifting gears a little bit, we have a question, an interesting one, I think, by Claire Schlesinger, who asks about the sort of interconnected structure that joint employment can introduce. So for instance, like Home Depot could work with multiple contracting agencies, right? And these agencies have multiple clients who have multiple sort of staffing needs, right? Like how might these sort of like interconnected, like longer, broader structures present both opportunities for through the law for unionization, but also like hinder some aspects of it?
You see tremendous fracturing. It's not just between one employer and one contractor. You often see contractors then subcontracting out and subcontracting out. I mean, certainly in the cleaning industry, office building cleaning, you'll see that. I mean, a lot of it goes to the point I think Millie was making about power. SEIU 32BJ, which represents all these cleaners and all these office buildings in New York City, is able to get contracts. And when the employers try to roll it over to another contractor, they have the leverage to get those contractors to recognize the union, sign a union contract. A lot of it is the density in the industry that the union has to be able to effectuate the terms and conditions of employment, to keep them higher rather than lower in an industry. The law is a very limited help in that situation. It certainly can help many workers, but when you have a lot of this fissuring, it gets very complex, and it's just, provides another out for an employer.
Well, as I think both of you sort of indicated, right, the race to the bottom is a particularly pernicious way that employers can exert tremendous amount of authority and power over workers. And unions sort of help create this kind of floor that stops this sort of free fall to as low as an employer could go. I would like to
go ahead.
Oh, I'm so sorry.
No, thinking about organizing, on the healthcare side, we didn't talk a whole lot about agencies, but when I think about petitions, we're organizing to organize in a facility, we're used to expecting that we file a petition for the institution, and the employer is then going to send in the list of who they say are the people in the bargaining unit. And oftentimes it both includes the people who are, regular, full-time, part-time workers. They're in the classifications that we're filing for, and that's right. Sometimes they don't include the names of people who happen to be activists for the union, and that becomes a whole other issue. But we also then see the employers will fill the list with a whole lot of other names of people who might have worked there for a couple of days, or who are working there and they're actually temp workers or from an agency. And so one opportunity is that in that kind of a dynamic, it used to be that we'd have to fight to, strike the names of the people who, weren't really a part of the bargaining unit, while we also try to speak to those workers and talk with them about what it means to be in the union, so that if they voted, they'd vote yes. But ultimately, when it came time to do the count, we would be saying, that person's vote shouldn't be counted. In this kind of a dynamic where if the agency then has staff in the facility and they are, nursing staff in this setting, just like the others, we as the union would file for all of them. So the nursing home, the agencies, the subcontractors, we could file for all of them. And that would actually really be an opportunity, because one, that bargaining unit that typically the employers want to make big so that the union will lose, because it'll be harder to get to your 50% plus one. From our perspective, organizing, the bigger the unit and the more opportunity we have workers ready to say they want to form their union, better to bring them all together and win as a strong unit, united across departments, classifications, agencies, and subcontractors, so that we would then, as I understand it, would get certified to represent all of those workers across the agencies. So they have 3 subcontractors, and they have a temp agency for the nursing staff, and they have the workers in the main house. We take it all, and when we bargain, we come together as that united group to make the demands that the workers want. So that's an opportunity that actually would be different for these employers, when they usually like to make the list large in order to make it harder for the union workers to be able to win on election day.
Well, that's a perfect explanation of why the joint employer rule that is supposed to go into effect on Monday will really make a difference. Millie's union will get that whole group, which they would not be able to do under the current Trump rule.
So, and of course, the nature and the concept of unions is power in numbers. Of course, more concentration is, of course, more power to the union. I would like to maybe combine two questions here, right? As I think local 100 legal department actually asks, under this new rule, would a joint employer need to be a recognized employer under the act, and what kind of stakes might that if an employer is or is not recognized? What sort of ramifications might that have? In addition to Alethea Jones' question about what about independent firms that actually own their subcontractor or have substantial interests in their subcontractor sort of status. So what happens if a main branch firm owns one of these subcontracting firms? Like, what type of complications might that have?
So for the first question, the NLRB has jurisdiction only over private employers. So if it's a public employer, the rule has no impact at all. The definition of employer under the National Labor Relations Act is quite broad. And so if it is a private sector employer that does engaged in any kind of interstate commerce, which almost all private sector employers are, they order their paper out of state or whatever, they're going to be under the jurisdiction of the NLRB. The question about the parent company and a subsidiary, generally, if the subsidiary company is a company under the law, incorporated or a partnership or whatever, they're going to be on the hook. If it's a situation, so I don't know if that's actually answering the question. There are certain situations where the parent company is really controlling the other company, and they're viewed as the same employer. There's this single employer doctrine. I'm not sure that answers the question, but these business entities are, for a lot of reasons, are usually separate companies because the parent company doesn't want the potential liabilities of the subsidiaries. So that situation, I haven't seen that kind of situation arise under the joint employer rule. I'm not so sure how it would arise.
And maybe pivoting just a little bit from an anonymous, I think, questioner, like how does or does not this decision actually relate to other contractor and other employee distinctions? The example that this person used was like eligibility for benefits, but also like more broad categories as well. So,
the NLRB only enforces the National Labor Relations Act. So it doesn't enforce the Fair Labor Standards Act. It doesn't enforce the OSHA Act. So, and each agency has a different definition of what a joint employer is, what an independent contractor is. So it depends on the agency. So the NLRB's rule would not be applicable to other agencies that provide benefits. Other agencies will look at what other agencies do, but the rules have been different historically. And I would expect that would remain the case because the law develops in different ways under different statutes.
So Ellen, if we were to talk through an example, if we had workers at a facility who were organizing and protesting against unsafe working conditions, and some of the activists were disciplined, maybe even terminated because of that organizing, and you sort of the main employer and you had a couple of subcontractors, are you saying that the workers, that the employer, the main employer, the subcontractors might be liable for a ULP, an unfair labor practice, because the workers were organizing, around the workplace issue? But if the persons then had issues, say, with OSHA, that OSHA might treat it differently?
So if if workers are retaliated against because they collectively protest health and safety matters, the NLRB would clearly take that case, and because it's unlawful to fire workers who are protesting their terms and conditions of employment. OSHA, in that case, a retaliation kind of case, OSHA could also have jurisdiction over that case if it involved an OSHA, an OSHA rule or an OSHA standard. And there is some coordination between agencies. So there.
So let me ask you this.
Yeah.
So Ellen, but then for the question of who's actually so let's say
Liability.
I work for a subcontractor, you work for the main house, we file a complaint because we were both disciplined for needing workers to demand a safe workplace. Is it the case, under that example, would the NLRB look at both the main employer and the subcontractors as liable? And that's what the new rule would provide. However, OSHA might say, well, it only happens with the subcontractor, maybe not, the main employer is liable.
Could happen. Yeah, I don't know. I've never seen a joint employer rule coming out of OSHA, but under the NLRB, absolutely. I mean, it's been long-standing that there is joint employer liability for both employers, the subcontractor and the main employer, if the employer who didn't do the actual retaliation knew about it or should have known about it and had the power to stop it and didn't do it. That's sort of historical law at the NLRB. The difference now is that with the new joint employer rule, it's easier to establish joint employer status and to hold the big company liable. Under the Trump rule, the subcontractor would be stuck with having to remedy the ULP and pay the back pay or whatever. And often they don't have the money and they go under. So being able to hold the big guy liable, which the rule makes it much easier to do, is really a significant change.
And maybe switching veins just a little bit, I think we have a really interesting question from Matt Siegel, who is a subcontractor at a very large firm, who knows that there are dozens and dozens of agencies at his particular place of employment. And in organizing discussions, he finds that they only have leverage over their small team of 8 people. Like, what type of precedent is there for organizing multiple of these agencies together? Is there a precedent? Is there hope?
I don't know that there's precedent, but I think you could try to get a number of those agencies together, file a petition for representation, naming a number of those agencies as well as the company that's doing the subcontract, as long as the workers share what's called a community of interest, that they're there's a similarity in their working conditions and the supervision and the way the work is done. Because the joint employer rule says 2 or more employers can have control. So it just depends on, the working conditions of the various groups, and you'd certainly want to group similar workers together and not include workers whose working conditions are really different. But I think the potential is there. I don't know how many you're talking about, but the potential's there. You're gonna end up in a big NLRB hearing in all likelihood, to determine who the joint employers are. But
And I think this I might be the last question, and I think we might call it. Alethea Jones actually asked this question about this recent lawsuit between Amazon, Trader Joe's, and SpaceX about the NLRB being unconstitutional. Like, what? How might the joint employer rules sort of figure into those type of discussions, or inspire this type of fear in these particular employers?
Yeah, well, these employers certainly are quite fearful of the NLRB because they've gone to this extent. I mean, it's mind-boggling to me when you have about 6% of private sector workers unionized, that the threat of growth, any kind of growth, is so damning for them. I mean, these lawsuits, in my view, are really frivolous, but we have a United States Supreme Court that has made it very clear that they have a very negative view of unions and workers, and they are protecting employers. And we also have a lot of intermediary courts in the federal system with judges who share similar sentiments. And so these employers are filing their suits in Texas, looking for a favorable forum for their cases. They're going to go up. I don't know if the Supreme Court will take cert in these cases. I don't know that they'll get that far, but they could. And they're phrasing the litigation in a way that I think they think would appeal to the current Supreme Court. I mean, I think they're frivolous, but I thought other cases were frivolous and I've been deemed wrong. So we'll just have to see. But it is really a reflection of how threatened employers feel from an active NLRB general counsel who, I mean, the NLRB just issued a decision yesterday in a case involving Home Depot, of all places, where workers were wearing insignia with the Black Lives Matter BLM, and they were told they couldn't do that. And the board reversed the judge in that case and said, look, these workers had been complaining about racism on the job, and they had the right to wear this insignia. It's protected under the National Labor Relations Act. I'm sure this sent Home Depot, off the charts, and it will be appealed. But you have a general counsel at the NLRB right now who's been very aggressive in protecting workers, and you have a board that is dominated by appointed by a Democratic president, who also is very devoted to what they view are the purposes of the National Labor Relations Act, which is to protect workers' rights to organize and to encourage collective bargaining. And those employers don't like that.
Indeed, they do not. Looking at these employers of scale like Amazon and SpaceX, even are more familiar ones like Trader Joe's, are, I think, all quite nervous about how these new developments are going. So it is about that was our last audience questions. It is about 8:30. I think we could we're gonna sort of shift gears to look at the next entry in this NLRB series, and we can sort of shift over to GR and take it from there.
Thank you, Cameron. I want to welcome everyone to join us for one more of these sessions. The top is going to be CEMEX and new frameworks for bargaining. Our guest speakers are going to be Tony Ruiz, who is an international organizer with the IBEW. We're going to have Ray Heineman, who is an attorney with Kroll, Heineman, Sets, which I just butchered that, and Parsons. And Teresa Poor, who is the regional director for the board Region 29 in Brooklyn, and they will be moderated by Eric Blanc, who is a faculty member in labor studies at Rutgers University. So please join us for one more of these incredible conversations next week.